So there are two programs that your client as well as the tenant can pursue to get some of that back rent.
Your Honor, may I make a suggestion to counsel? Mr. Rucker, if Ms. Henry does participate in Sarah, I highly encourage your client to participate as well, because that way the payment will be sent directly to your client as opposed to having to go to Ms. Henry first. Additionally, if you provide the documents, the application will, like the ledger and any other information they request, the application will be processed much quicker as opposed to landlords who don't participate or refuse to participate, I guess I should say.
Okay. I appreciate that, and I will pass that on to my client. And the acronym is Sarah.
Yep, CERA. It stands for COVID Emergency Rental Assistance. So it's two programs, Wayne Metro and Wayne County.
All right, thank you.
All right, thanks, Mr. Rucker. See you soon.
Certainly, bye-bye.
All right, everybody, we're back on the record. This is case number 21-1901 LT, Dillard Homes Realty versus Tracy Paisley.
Ready, Your Honor. Good morning.
Good morning, your appearance.
Thank you, Melvin Babby, appearing on behalf of Dillard Homes Realty, LLC.
Okay. Ms. Paisley, can you tell me your full name for the record?
Your Honor, while she's muted, David Morawski, 57261. We are filing an appearance for Ms. Paisley today. I apologize for not sending one sooner. There was a mix-up between getting the retainer back from her. But we are filing an appearance today.
All right. Are you prepared to go forward with hearing today?
I would like to speak with opposing counsel and Ms. Paisley in a breakout room, please.
All right, we'll put all three of you together.
Thank you.
Thank you. All right, I see the attorneys back on the Dillard Homes Realty versus Tracy Paisley, case number 21-1901 LT. Are we ready to go, gentlemen?
Thank you, Your Honor.
Yes, Your Honor.
All right, your appearances.
Thank you, Melvin Babby, appearing on behalf of the plaintiff, Dillard Homes Realty, LLC.
Good morning, Your Honor. David Morawski, 57261 on behalf of the defendant. And Your Honor, as this is my first appearance, I'd just like to say this is an eviction based upon a termination. My clients lived on the property for 10 years under color of title, and the basis for the eviction is based upon a deed that the plaintiff holds that came from a party that took title, allegedly took title from my client. My client is alleging that that deed out of her was forged. And as a result, this is going to involve some discovery having to be done in this case, because we're going to have to investigate the chain of title. We're going to have to investigate what the plaintiff knew when they took title, because if they had knowledge of my client's occupancy and claim of right to the property when they took title, they have a duty to investigate. I would preferably like to file a quiet title action, but that has to be done by one of the two parties. And Mr. Babby has informed me that his client does not wish to do that. So it looks like my client would have to do that. And if and when that does happen, I'd like this case to be stayed. But in the meantime, I'd like to file an answer in this case. And if we proceed in this case, as opposed to a quiet title action, I'd like some time for discovery.
Sure. Mr. Babby, what do you say?
Thank you, Your Honor. As this is a summary proceeding, this is, I believe, the third hearing on this matter. The defendant had ample time to make these arguments, to provide documentation to show that there was some sort of fraudulent deed. We at this time we're entitled to evict the defendant. It's been 30 days. She hasn't provided any documentation evidence at this point to even put a scintilla of evidence as to what she's saying is truthful. This is prejudicing and delaying my client from taking over this property. So we would like to proceed, and however the judge, your honor, would like to move forward, we're satisfied with your order, obviously.
And Your Honor, if I may respond.
Yes.
Your Honor, this type of case that, I mean, when you're alleging a deed as a forgery, you can't just present document evidence. You have to do discovery on this. But I can say for this, that I took a look at the deeds. The property was sold to her by a party, and the same notary on that deed into her is the same notary on the deed out of her. And there's some affiliation between her grantor and the plaintiff's grantor. It looks like they had forged the deed out of her and then turned around and sold it. This property was purchased at some type of public sale, either mortgage foreclosure or tax sale. So I'm not sure what is going on here, but there are definitely some questions of fact as to whether or not the deed into the plaintiff is enforceable. And the only way to do that is to file an answer and do some discovery on those issues. And
How much
discover.
time do you need, Mr. Morosky?
I mean, typically on these type of cases, it's going to take some time, Your Honor. I need to find out some information from the notary. I need, if we're going to allege a forgery, a handwriting expert will likely be retained. That's why I think it's probably better to do that in circuit court. But if we're going to do it here, I mean, I would ask for 90 days, Your Honor. And I believe this is only the second hearing, but
It is the second hearing. When counsel said we've adjourned this 3 times, I looked back at my notes. I adjourned it to give Ms. Paisley time to speak with an attorney. She has now retained counsel who appeared on her second court date. So the issue is not delay.
And I apologize for that, Your Honor. I thought it was
But I don't want to hold it for 90 days.
Well, Your Honor, I mean, if you give us 60 days, I mean, at the very least, it gives us time, if possible, to file the quiet title action if need be, and we can address this case if that gets filed. Otherwise, we'll proceed in this case. But I want to be able to give my client some options. This is a serious allegation. She's lived in the house for 10 years, and then all of a sudden somebody just comes up and claims that they own the property.
Your Honor, if I may, I believe at this point, since this is a summary proceeding, we could potentially ask defendant questions with regards to the property and the deed and things of that nature. And I believe what defendant is asking for is essentially an answer and a counter complaint in this court. And I don't know, if you wanted to provide an opportunity to provide an answer and a counter complaint, I think 60 days is excessive considering we're dealing with tenancy issue here.
Well, I'm sorry to interrupt. I thought you were done.
No, it's okay. And so ultimately, whatever the court decides, we're okay with. And if whatever time is allowable, we think it just needs to be consistent with what the time for an answer would be in a standard setting.
Well, Your Honor, I think the 60 days is adequate because I'd like a week or so to file an answer, and then they would have time to respond. Any discovery would take 28 days. Additionally, Your Honor, as far as any issues today, I mean, I believe there's enough to show that there's a triable issue of fact and that the hearing not go forward today. But additionally, this court has equitable jurisdiction as to any claims of title in summary proceedings. It's limited, but it specifically issues in land contracts and claims such as this. So this court does have jurisdiction to hear the claims. And so the fact that these are summary proceedings should have no bearing on any defenses or counterclaims when it comes to title to the property, because this court can hear that. And due to the importance and gravity of the situation with respect to my client, I think she needs to be afforded any of those rights, whether they be raised here or in circuit court. And the summary proceedings, can be stayed, while the title issue is being litigated, whether it's here or in circuit court, Your Honor.
Hello?
Just 1 second. Hold on just 1 second. All right, here's what we're going to do. Mr. Morosi's going to file an answer, and then the parties will be able to engage in some discovery. We'll adjourn this matter to February 7th at 11:30 a.m.
Your Honor, when would you like that answer filed? I can get to you in 7 days if that's okay.
That's fine. All right, thank you all.
Thank you, Your Honor.
Thank you, Your Honor. Have a great day.
You too.
Mr. Babby, I'll be in contact with you.
All right, thanks. Nice to meet you as well.
Yeah, yeah.
All right.